All right. Ms. Wallace, your microphone is on mute.
Thank you.
All right. I think we can proceed. You're it.
Okay, you can hear me fine?
Awesome. Thank
Okay,
you.
great. This case deals with a question of whether the trial court abused its discretion by not finding that there had been a sufficient facts to establish a substantial change in circumstances warranting a time sharing. The facts that are relevant go over a period of quite a few years. The divorce trial occurred in Sarasota in 2015. At the time of the divorce trial, the child, just one child, had just turned 2 years old. The mother was living in Indiana, and there had been a number of facts to establish that the mother had been battling a problem with alcohol. She'd driven to Indiana with the child at the time the parties separated, was missing for a while, had been entered a rehab program, and had some treatment. Judge Walker wrote a 22-page opinion, and he did reflect in that opinion when he awarded, or basically found, that the child would stay here in Sarasota with the father and entered a long-distance parenting plan. He found that the wife had struggled with alcohol, but that she had appeared at that time to be in recovery. She testified that she had not had alcohol for several months except for a short relapse. There was no one to dispute that testimony, and the long-distance parenting plan was entered. That was 2015. Fast forward, the mother exercised time sharing in Indiana the summer of 2016, and then thereafter, except for a couple weekends, didn't exercise any time sharing. The father testified in the supplemental petition proceedings that it would go months that he would not hear from his former wife, that she would not try to contact the child or have any contact. So basically she was not seeking any time sharing. So nothing happened except that she was not having any contact with the child at that time.
Ms. Wallace, can I interrupt you?
Sure, absolutely.
These cases are really sad, and it really is unfortunate whenever any of us would read or about cases, people who are struggling with alcoholism. That's really a serious thing. But my question to you is that when we're looking at the modification, I think we all know that the legal standard for a modification proceeding basically simply says that there has to be showing of a substantial, material, and unanticipated change in circumstances, and then the determination that the modification is the best interest of the child. So help me out, Ms. Wallace, because I'm looking at the final judgment. The final judgment, and you've stated beautifully that, yes, the mother drove the children to Indiana. It was a multi-day bender. And I'm looking at the final judgment. There was multiple DUIs, there was multiple unsuccessful attempts at rehabilitations in various programs, and the judge in the final judgment basically concluded, and I quote, and I pulled that from that, wife's recent history fails to establish a significant, stable period of meaningful sobriety. So with that and the underlying final judgment. And I appreciate the fact that you said that during a period of time that the mother was getting better, at least was trying to get better. But help me out with the standard, the governing legal standard that the case law says is basically, it's an extraordinary burden to prove the substantial change in circumstances, given the fact that mom is an alcoholic. She's always been an alcoholic. That has never changed. And you have that statement in the final judgment that said that her recent history fails to establish a significant, stable period of meaningful sobriety. And fast forward to what's happening now. Isn't it the same right now?
I don't think so. I would have to disagree with your recitation that she had been in multiple programs at the time of the divorce. I don't think that is true. I think that she had entered one program in Indiana that had been her first time. The DUIs were quite remote in time before the parties married. She had another young child, and my client had a young child, so she had been a mother here and, you know, had not had any issues during their marriage. So that trip to Indiana, the program that she entered, that was after many years of not really having an issue. I think another big difference was she was admitting her alcoholism, she was getting help, she was going to AA. There were family support at that time. There was testimony from my client's parents that they were in the same area to help. And I think all of those things basically influenced. I mean, Judge Walker obviously had given custody to my client, but he gave her some time sharing. It was limited. It was summer hours. She could have come down here, but there were, let's say, some safeguards in place. Dramatically different, I say, by 2018. By 2018, the facts clearly established 3 different alcohol programs, 2 of them residential, the last one being 6 weeks. She gets out of the program, she immediately is drinking. She never admits that she's alcoholic during the course of 2 very, very lengthy different hearings that occurred during the supplemental petition phase before the trial, in which she was ordered to prove that she could maintain sobriety. This is a huge difference than before. Her own counsel suggested the SoberLink program. She failed. I mean, she didn't take it over 130 times. She missed tests. I mean, the trial judge.
Wallace,
Yeah.
I have a question. I understand your argument, and maybe I would have done something different if I was a trial court, but you're asking us to exercise the luxury of 2020 hindsight that involves second guessing what this trial court did. And really, you'd have to demonstrate something along the lines that no other judge in the face of the planet would have done what this judge did in the face of the disputed facts that the judge found weren't enough. And he's a pretty skimpy order denying the modification, saying there was no sufficient change in circumstances. She just used alcohol before, she continues to use it, and that's all it really says. Doesn't go into a lot of the detail. And I'm going to guess that there wasn't a motion for rehearing that you asked the judge to elaborate some of those findings. Is that a yes or no?
I did do a motion for rehearing.
And you just got a
It was
flat
denied.
denial?
Yeah, flat denial without a hearing, yes.
Okay,
The other
so
thing.
well, then I'm leading up to this question, then I'll be done. How does the facts in this case, what's your argument that the facts had an adverse effect on this minor child, the use of the alcohol, the
Well, I
continued
think-
use of the alcohol?
Right. First of all right, so during the entire time, she had no time sharing with the child other than 3 months, 2.5 months after we filed the supplemental petition, when she was having time sharing with the child with her then boyfriend present.
Was there some sort of an expert that testified that had an adverse effect on the minor child? I mean, that's a statement of fact. How does that affect the child's well-being?
He was present during the time that she was very, very drunk, and the person she lived with had to call my client to come get the child immediately.
And did the trial court say that adversely affected the child? Was there an expert that said that? Or is this an assumption that you want us to assume, of course, it had an adverse impact?
There was no psychologist to say that that would have an adverse impact. Now, I think, okay, if you look at some of the case law, okay, there is case law about substantial change in circumstances. It basically says you don't have to find that the child was immediately affected, but if there's a risk to the well-being of the minor child. If someone is completely drunk and a young child like this, I mean, do we have to have an expert to say that he could have been hurt, that she could have put him in potential harm, that her behaviors are not impactful to his emotional well-being. I mean, it doesn't seem to me that we need a psychologist to say that. It seems that that's something that we can find as a person. And if you look at the case law, like look at Allen, look at Oshiro, where there were circumstances where, you know, Oshiro, at the time, the wife had been taking pills. They found that she was potentially abusing prescription drugs without a prescription. They put
Ms.
in.
Wallace, but if I may, but isn't our analysis and our review is to basically look at what the trial court has done. And if everything that you said, we have to look what was mom at the time of the final judgment and how was mom after the final judgment, whether there's been a real change. And I pulled back the final judgment. The final judgment did describe multiple programs that she tried to go into. Not all of them were residential, including AA. And so I think for our analysis, if mom's condition, she's an alcoholic before, she attempted, not residential, multiple programs. You had a statement from the trial judge and the final judgment saying, she fails to establish a significant, stable period of meaningful sobriety. And she'd taken the child again, by driving up to Indiana, harm, all of that. And then right now, and then you have the case law that said that this is an extraordinary, it says the petitioning party has the extraordinary burden to prove the substantial change in circumstance. So this is where I'm struggling with, because it's sad. Mom is an alcoholic. She remains an alcoholic. The question is, and given the abuse of discretion standard, which, that's a real tough standard to overcome. And Judge Valenti, I think, explained it beautifully. What has drastically changed from before to after to warrant that the judge totally blew his discretion, totally abused his discretion in coming out the way he did?
Well, again, I think that what is different and what is that she had been for several months not drinking. And remember, she's only getting several weeks in Indiana. I mean, I think Judge Walker was supporting why he was having dad, the child stay with dad and be with dad as a 2-year-old, which was is unusual sometimes in family law, obviously. And he's saying this is why, because she has been in recovery for several months. He was noting the history. That is so different than what happened since then. She could not go a week. She couldn't even go 4 days without missing or failing tests. So where she might have had problems or had a brief relapse, she wasn't drinking continually. There was no evidence of that. She was maintaining a job, contrary to 2018 and since then, when she could not even make it a week. And the Judge Walker gave her a chance after what was the purpose of suspension of on a temporary basis, if not to, he says repeatedly, to demonstrate to the court that she could maintain some period of sobriety. That was the purpose of the temporary orders. And she didn't do it. And she failed and failed and failed. And he blasts her all the time about not putting the child first and not being able to, couldn't have time sharing because she couldn't go a week. The last chance he gave her was, okay, 90 days, you're still going to test. If you can go 7 consecutive days, I'm going to allow you to have time sharing. That's what he said. And she didn't. And then he still denied it. And I think, again, the Allen case, the Oshiro case, I understand the standard in supplemental petitions for alimony, for lots of other things. There is, to me, a difference in time sharing because of the language in some of these cases.
What's interesting, Ms. Wallace, each of the cases that you cited to actually supports that supports affirming the trial court's decision. If you look at every single case that you cited to, there's really no cited authorities in your brief that reverse on the basis that the trial court was required to modify based on the substantial change in circumstances. So I know you make reference to it, but I just want to give you an opportunity to at least to try to elaborate if you'd like.
Well, the Oshiro case. The Oshiro case was the one where they had agreed in the final judgment, they amended it that she would have drug testing. The former husband then files a supplemental petition alleging that she was abusing then prescription or illegal drugs, that she was basically continuing to do it. Same kind of thing. Gave her a test. She's going to have drug testing. He alleges that she's abusing it. And the former wife argued again that the court had erred because they hadn't shown a detriment to the child. And there's a good opinion, says under these principles. Former wife.
You've got about 2 minutes left. You've used up most of your time, but you have 2 minutes if you want to use it with whatever else you want to say.
I think those time sharing cases show that where it's demonstrated that there's a risk to the well-being of the child. Here, there was no question that the progression of her involvement in alcohol and how it was running her life and her, I mean, if there was any time sharing, we knew she couldn't go 2 or 3 days. And you have a young child, she's asking to have time sharing 1,200 miles away. I think, Judge Krug could have entered an order still allowing her some time sharing here, but providing for safeguards for the child. He even makes a comment, something like, well, if she has if she does something, we'll address it. Well, we all know how quickly can you address something if the child is 1,200 miles away, the mom now who's still drinking, unable to attend to the child. I mean, the potential risk to this child is great. And for us,
1 minute remaining.
okay. And I think the Allen case too. I think that the circumstances showed that she had had an alcohol problem, but then she was driving with the child. I just think that there are circumstances here and facts here that are vastly different than the time of the final judgment. The extent of the years, she had been Baker acted on one occasion. It was not documented what kind of program she'd been in at the trial court level, but I know that those had been many, many years before. And, again, if it is not modified, we are looking at someone that is an admitted alcoholic 1,200 miles away now with no one monitoring it and a young child at risk by himself.
All right, Ms. Wallace, that concludes your time. Thank you so much.
Okay.
A great day. We're going to go on to the next case, but I'll